Good morning, I'm Ibrahim Kamara. I'm here to present on injury in fact. Introduction. Injury in fact requirement is a phenomenon that stipulates certain conditions for one to have standing in a particular case. It involves substantial evidence backed by precedent cases or laws. Allen Claridge Plaintiff v. Rockview Incorporated is an example of injury in fact where the plaintiff accused the defendant of violating his rights on 9 counts. The counts were substantial to warrant the guilty nature in the case. Injury in fact requirements. Injury in fact requirements. Injury in fact requires damage to a legally protected interest which is concrete and particular as actual or imminent, not conjectural or hypothetical. The example of injury in fact happened in the Allen Claridge Plaintiff v. Rockview Incorporated case. The plaintiff sued the defendant on 9 counts, which include violation of the Stolen Communications Act, 18 U.S.C. 2702, violation of California Unfair Competition Law, violation of California Computer Crime Law, violation of the California Consumer Legal Remedies Act, breach of contract, breach of the implied covenant of good faith and fair dealings, breach of implied contracts, negligence, and negligence per se. Injury in fact requirement continue. Contrarily, the court dismissed the plaintiff complaint using substantial evidence and laws. The court said that the plaintiff failed to allege an injury in fact sufficient to support Article 3 standing. And not only is there a paucity of controlling authority regarding the legal sufficiency of plaintiff damages theory, but the court also take note that the context in which plaintiff theory arises, the unauthorized disclosure of personal information via the internet, is itself relatively new and therefore more likely to raise issues of law not yet settled in the courts. Consequently, the court found plaintiff allegation of harm sufficient at this stage to allege a generalized injury in fact if it becomes apparent through discovery that no basis exists upon which plaintiff could legally demonstrate tangible harm via the unauthorized disclosure of personal information. The court will dismiss plaintiff claims for lack of standing at this positive motion stage. Notwithstanding the court's conclusion that Article 3 standing has generally been adequately pled at this juncture, the court further concludes that plaintiff has nonetheless failed to allege the more particularized elements of injury with respect to several of plaintiff's numerous individual causes of action. The court now turns to the sufficiency of plaintiff allegations with respect to each individual claim asserted. Why have some courts found plaintiff to have standing? The court finds plaintiff to have standing because some contractual agreement or legal instrument such as state laws. The Supreme Court has set a boundary on standing and it debates that the plaintiff have provided sufficient legal evidence for consideration or not, because the plaintiff's rights and privilege has been violated or exploited by a defendant, which might be an individual or corporate body. There are several past cases which gave a plaintiff standing, because the standing is a complex and important issue in many types of legal cases, from everyday contract dispute to systemic impact cases. What constitutes substantiation and concrete demonstration of injury? Standing is a requirement within Article 3, which grants a judicial power. The judicial branch, federal courts, can only hear cases or controversies. In a 1992 case, Lujan v. Defenders of Wildlife, the Supreme Court clarified one important rule of the standing doctrine. To have standing, a plaintiff must state more than a mere generalized grievance about the proper application of the Constitution and laws. In other words, A plaintiff cannot seek relief which no more directly and tangibly benefits him than it does the public at large. Standing requires more than a generalized grievance. In Supreme Court precedent, the concept evolved in a requirement that a plaintiff must have a concrete and particularized injury. Is an injury concrete for Article 3 standing? An injury should be concrete for legal standing in any legal hearing. The Supreme Court fleshed out the concrete aspect of the injury requirement in a 2016 case, Spokio v. Robbins. Spokio runs a website that provides individual information to the public, such as marital status, age, occupation, and contact information. The plaintiff, Robbins, claimed Spokio offered incorrect information about him and he sought relief under the Fair Credit Reporting Act. The Supreme Court questioned whether Robbins had probably alleged a concrete injury. If Spokio's incorrect information caused Robbins to lose out on a job offer, then his injury is concrete. On the other hand, if Spokio merely provided the wrong zip code for Robbins, it is difficult to imagine how that, without more, could work any concrete harm. What obligation do private companies and government agencies have when a data breach occurs? You should first secure your operation, remove improperly posted information from the web, fix vulnerabilities, notify appropriate parties. Got the references. We have 3 different references. We have 2018, 2020, and 2021. One from the standing after Cambridge law. We also have the Georgetown Journal of Law and Public Policy. We also have Supreme Court clarifies injury in fact requirement for intangible harm.